Now I will discuss the section 54A, capital A, of the Criminal Procedure Code. This section 54A is a part of the chapter 5 of the Criminal Procedure Code, which makes provisions regarding the topic of arrest of persons. There are so many sections in this part 5. Therefore, I am delivering the lectures on this topic in various parts. So far, I have given lecture in 5 parts, and this is now the 6th part relating to this topic of arrest of persons. So, what is that section 54A? Section 54A, its heading is identification of person arrested. Identification of person arrested. Where a person is arrested on a charge of committing an offence, and when his identification by any other person is considered necessary for the purpose of investigation of such offence, then the court may, on the request of the police, on the request of the officer in charge of police station, direct the person so arrested to subject himself to identification by any person, any other person. So, in this situation, one suspected accused person is arrested, and investigation police officer thinks that his identification by some other person who actually seen that accused person while committing the crime, so his identification by such other person who is a witness to that incidence of crime, it is essential. Then in that case, officer in charge of police station makes a request to the court for causing this process of identification of the suspected accused person. And upon the request of such officer in charge of police station, the court direct the person so arrested to subject himself for such identification by that other person who is a eyewitness to that incidence of crime. There is one further clause in this section 54A. It says that when the person who is identifying the person arrested, that means the person who is a witness to that incidence of crime, when such person is mentally or physically disabled, when such person who is a witness is mentally or physically disabled, then such process of identification shall take place under the supervision of judicial magistrate. So when that witness who has seen that incidence of crime is mentally or physically disabled, then such identification process must take place under the supervision of judicial magistrate, and that judicial magistrate shall take appropriate step to ensure that such person, that is witness, such person actually identifies the person arrested, thereby using such methods with which that person, means witness, is comfortable with. And in such situation, such process of identification shall also be videographed. So this is the provision of section 54A. Now we will consider what is the relevancy of this identification process from the point of view of evidence. So for that, we have to see the section 9 of the Indian Evidence Act. It deals with the relevancy of such facts which are necessary to introduce the fact in issue. So Indian Evidence Act says, during the trial of any matter, evidence is to be given of fact in issue and relevant facts. Evidence of which facts is to be given? Fact in issue and relevant fact. What is fact in issue? That is the main controversial fact involving that matter before the court. That is fact in issue. And relevant fact, it may be connected in some way or other to such fact in issue. Now particularly section 9 of the Indian Evidence Act deals with the relevance of such facts which are necessary to introduce the fact in issue. Accordingly, this section 9 makes relevant the fact which establishes the identity of any such person, identity whose identity is relevant for the purpose of evidence. Identity of, so any such fact which establishes the identity of such person, that other fact is relevant and evidence of it can be given. So in case of criminal prosecution of any accused person, proper identity of that accused person is a facting issue. So any such other fact which establishes the identity of that accused person, that other fact is also relevant under section 9 of the Indian Evidence Act, and evidence of it can be given. And therefore the process of identification period is to be carried out. Why the earlier identification process is important? Because many times it becomes unfair to identify the accused in the witness box by the witnesses, because usually a trial commences after a long lapse of time since the incidence of offence. I will give you an example of it. Generally, I have delivered one lecture already also. 3 stages in criminal case, that is investigation, inquiry or trial. So now after the police arrest one suspected accused person, and if police came to know that incidence of offence, crime has seen by some other person, that means who is a witness. So during the trial, that other person may be called as a witness on behalf of the prosecution, and he will be asked during the trial in the court whether you identify the accused person. So during that time, it may possible that witness may not identify, because there is a long gap of time in between the happening of that incidence of offence, and now he is giving the evidence before the court as a witness. Therefore it is said it becomes unfair to identify the accused in the dock by the witnesses, because usually a trial commences after a long lapse of time since the incidence of offence. Therefore, in support of such identification of the accused by the witness at the time of the trial, it is also necessary, or it is better to have also the evidence of test identification parade proceeding. Test identification parade proceeding, which is to be conducted under this section 54A of the Code of Criminal Procedure. Now consider the following example. One Mr. A is accused of committing murder of B by stabbing. So A is accused of committing murder of B by stabbing B. And here one C is an eyewitness who had just a fleeting glimpse of the accused A, to whom he has seen for the first time while stabbing the B. So consider this offences happen, the incidents of offences have happened at some isolated place where A is stabbing B with a sharp weapon, and suppose that C, who is eyewitness, he is passerby. He is going, while he was going from that place, he is a passerby. He sees that incident for few seconds. So it is said that he had seen that incident with a fleeting glimpse, and he do not know that accused A, because he is seeing that accused A for the first time in his life. Then that C, who is an eyewitness, he describes the physical features of that accused A to the police. Then the police, after the investigation, arrest one person of such description. So description is given by that C regarding that accused A. Then the police put the arrested person among several other persons of similar stature and color as far as possible, and then call the eyewitness C to pick up the person to whom he had seen stabbing the B. Now here, if the C is able to pick up the person correctly, then it ensures that the eyewitness is telling the truth and that the police investigation is on the right track. So therefore, it is better to have this identification parade proceeding immediately happening of the incidents of that crime. Regarding its importance of test identification parade, there is one judgment of the Supreme Court. This judgment is reported in the Supreme Court cases year 1995, volume 2, page 64, and the parties before the Supreme Court are Suresh Paul versus State. So it is the observation of the Supreme Court regarding the importance of test identification period. Even though the substantive evidence of identifying the witness is his evidence made in the court, means that prosecution witness comes before the court and he identifies the accused person before the court during the trial, it is called as substantive evidence. Even though the substantive evidence of identifying witness is his evidence made in court, but in cases where the accused person is not known to the witnesses, witnesses who claim to have seen the incidents of crime, then identification of the accused person at the earliest possible opportunity after the occurrence of such incidents of crime by such witness is of a vital importance. It is very important. What is important? Identification of the accused at the earliest possible opportunity after the occurrence of such incidents of crime is of vital importance with a view to avoid the chance of his memory. His means that witness, to avoid the chance of his memory fading away by the time he is examined in the court as a prosecution witness after some lapse of time. So when there is a long gap between the happening of that incidence of crime and actual commencement of the trial before the court, and when that eyewitness is called before the court, by that time it may possible that if that witness is not knowing that accused person any time before, he has seen for the first time while committing that offense, it may possible that due to such lapse of times, gap of time, the memory of that witness may get fade away and he could not properly identify the accused person. And to avoid such a risk of the important witness with relation to important eyewitness, is better to have test identification parade proceeding immediately after the occurrence of incidents of crime. So I stop here. Thank you.